Hello. I expect you've already heard of the court case now that's happened on Friday the 19th of June 2015 that has judged that the Jehovah's Witness organisation are liable for the sexual abuse of a small child perpetrated by a ministerial servant. This is a groundbreaking case because it's a civil case, not a criminal case, and it holds the organisation liable for something that they've done that has allowed abuse to happen. This is not a case of one bad apple, as Jehovah's Witnesses often like to repeat. I'm going to go through the judgment with you and explain the case. So the judge says that this case is brought in two ways. Firstly, it's claimed that the Jehovah's Witness organisation is vicariously liable for the sexual assaults committed by Peter Stewart when he was a ministerial servant. Secondly, it's claimed that the Watchtower Society are vicariously liable for the actions of the Limehurst elders who in 1990 negligently failed to take reasonable steps to protect the claimant from Peter Stewart once they knew he had sexually assaulted another child in the congregation. So first of all, the judge goes through the facts, which are quite harrowing. He says, according to the claimant, she was subjected to sexual abuse by Peter Stewart from 1989 when she was aged 3 or 4 until 1994 when she was aged 9. The abuse occurred at least once a week. It occurred in her house, his house, other people's houses, at Kingdom Hall, out on field service and, disturbingly, at the Don Valley Athletic Stadium in Sheffield, where witnesses used to have assemblies. Now, I find that a horrific concept, that thousands of witnesses can be sat in a stadium listening to pontificating pious talks while a member of the Jehovah's Witnesses is sexually abusing a small child in the background somewhere in the stadium. It says the abuse stopped in 1994 when Peter Stewart was arrested for abusing a different child. So our victim is aged 9 at this point. He goes to prison, and at the time when he's in prison, in the 2000s, the mother of the claimant in this case finds out that her own daughter has been abused by him. So she writes to him in prison and says, has he abused my daughter? And in June 2000, he writes back, and in his letter he admits the abuse and he apologises for the hurt and damage he's caused the claimant. So when she gets the letter back, the mother, she goes straight to the elders and shows them it. The judgment says when nothing was done, she went to the police. In May 2001, the police interviewed the claimant. When the police thereafter went to see Peter Stewart about the allegation, they discover that he's died. So our claimant brings a case not against him because he's dead, but against the Jehovah's Witness organisation for their failure to act. First of all, the judge discusses limitation. He says that when you bring a claim, you have a limited amount of time to bring a claim. And the elders claim that the mother knew of the abuse in 1990 and therefore should have brought a claim then. She claims that she doesn't know of the abuse until 2000 when she writes to him. So why are the elders saying she already knows? Well, this is what happens. Before he goes to prison, in 1990, the elders have a judicial committee with him, and he admits abuse to the girl that he's gone to prison for. He admits abuse to the elders. He's asked if he's ever abused any other child, and he says no, he hasn't. He says he's very sorry and it won't happen again. The judicial committee decided that because he was remorseful and genuinely repentant, he shouldn't be disfellowshipped. Instead, they'll just give him a reproof. And they say that they then warned all the parents privately in the congregation not to leave their children alone with him. So they're saying we warned people at that time in 1990. The mother says differently. She says that if she'd been given these warnings, she would have never allowed her children anywhere near him and the abuse wouldn't have happened. In fact, horrifically and ironically, at his court case in 1995 for this other child, the mother writes him a reference saying what an upstanding person he is. She says if she was warned in 1990 not to have children near him, she would have never written him that reference in his court case in 1995 where he subsequently went to prison anyway. She says no member of the congregation, publicly or privately, were told what Peter Stewart had done. So, in fact, even worse than that, when she finds out that he's abused, before she finds out, she hears people gossiping about him and saying that he's a child abuser. And she says, I don't believe this is true. And she tells these people that she's overheard she doesn't want to hear any more about it. And she says, stop talking about it in front of me. But afterwards, she goes and speaks to an elder. And she says, is it true that the elders knew something like that about Peter Stewart? And he says, this elder, Alan Orton, says it's not true. And he added that if the elders had known something like that, that Peter Stewart would have been dealt with. She then goes to speak to a circuit overseer, Paul Presland, and she asks him the same thing. And he says that she told Paul Presland that she'd heard that the elders had known Peter Stewart had been accused of sexually abusing the other child. And if they had done something about it at the time, then he wouldn't have been able to abuse her daughter. In her statement, she stated that Paul Presland replied, the elders would never do that. So the judge has these two conflicting statements. The elders that say they did tell her in 1990, and her saying I was never told. The judge rules that she's telling the truth and that for whatever reason, she was never warned and neither were any of the other parents. And in fact, the judge says, her efforts to discover what the elders actually knew were thwarted by what I am satisfied was the negative reaction of both Alan Orton and Paul Presland. So he says no, she didn't know about this until much later, and therefore he says she can still bring a case. In fact, the judge says a refusal to disapply the limitation period would mean the end of this action for her. So he's saying if I hold her to the statute of limitations, section 14, there will be no action. So he says I am satisfied that a fair trial remains possible. It is equitable to allow the action in relation to the assault claim to proceed, and direct that the provisions of section 11 should not apply to that part of the case, so the case can continue. So then the judge goes on to discuss whether there is vicarious liability. He says vicarious liability is established in two stages. The first stage establishes the essential elements of a relationship, because we're talking about people who are not linked in any other way other than they're part of a group together. So say if you were a member of a walking group, you wouldn't necessarily be liable to warn somebody else in the walking group of somebody else who you knew was up to something. It'd be a good thing to do, but you couldn't be taken to court if you didn't do it. So the first stage is the essential elements of the relationship. And it relies on a case called E versus the English Province of Our Lady of Charity. And this is a 2013 case. One of the great things about this case is that it relies on a lot of very recent judgments. In that 2013 case, a priest appointed by a diocesan bishop to visit a children's home sexually abused a child at that home. And the judge says, vicarious liability has moved beyond the confines of contract of service, right? So you don't have to have a contract of employment to establish that there's a relationship between the parties. This is something that the witnesses have often relied on. They've said, well, we don't employ our elders. They're not paid. They don't get a house. They don't get a stipend. They don't get a pension. They're just volunteers. There's no contractual relationship between them. But this case says that vicarious liability doesn't rely just on a contract. It's gone beyond that. It says, how do you decide if there is a relationship? Well, there's four essential elements: control, organisation, integration, and an entrepreneur test. And then he goes through each of those four elements. Now, the Watchtower lawyer argues that members of the congregation are not controlled by, fully integrated into, or obedient to the organisation of Jehovah's Witnesses in the same way that a full-time clergyman is. They often do make that distinction, don't they? They say we're just volunteers, clergy get paid, it's completely different. The judge dismisses that. The judge says this. It says, in relation to control, it's apparent from the structure and governance of the Jehovah's Witnesses that Being a Jehovah's Witness is a way of life for all members. It's not confined to the attendance of services. It affects every aspect of one's daily life. So he says there is control. He goes on to say the sanctions available to a judicial committee are wide-ranging and include reproof, removal, deletion of an elder or a ministerial servant and disfellowshipping. And he says if in fact an elder's expressed concern about a ministerial servant and is removed, the matter's dealt with by a judicial committee, there's no appeal from such a decision. So he says that satisfies the element of control, the fact that you have judicial committees and punish people. He also says the high level of control over all aspects of a Jehovah's Witness is arguably a closer relationship than that to be found of in an employer-employee relationship. And I would agree. When you have a job of work, my boss can't control what I think, what I believe, what I wear, and the things that I do outside of work. He can inside work, but not outside of work, whereas a Jehovah's Witness is controlled all the time. So he's actually saying it's a stronger relationship than a contractual relationship. So that element is satisfied. The second element, organisation, he discusses the hierarchical nature of the witnesses, the structure. He says there's prescriptive guidance as to how a ministerial servant and an elder should serve and act and behave at all times. The organisation element is satisfied. As to integration, this test comes from Lord Denning's observations in a case in 1952, wow, quite an old one, where he says, the test is the relevant person part and parcel of the organisation or just an accessory to it? So he discusses Lord Denning's test and he says a ministerial servant deputises for an elder. He assists the elders not only with routine administrative tasks but also standing in on occasions with a teaching role. One cannot become an elder without first having been a ministerial servant, and as such a ministerial servant is part and parcel of the organisation and integral to it. And regarding the last test, the entrepreneur test, this is not somebody that's just kind of self-employed, and just contracting out services to the organisation. It says the description of his activities certainly did not resonate with being an entrepreneur. His duties are solely to serve the interests of the organisation. He is constantly working for the good of the organisation of Jehovah's Witnesses and not for himself. So he says, consequently, he says the relationship between elders, ministerial servants and the Jehovah's Witnesses is sufficiently close in character to be one of employer-employee, that it is just and fair to impose vicarious liability. So he judges all those four things have been satisfied. Yes, we can impose vicarious liability. Now, interestingly, the witnesses tried to change the way elders and ministerial servants were appointed recently, didn't they? So they're not appointed centrally anymore, but they're appointed by circuit overseers. And I wondered if that was a way of distancing themselves and saying we're not liable for those appointments anymore. But in fact, none of this relies on how they're appointed or when they're appointed or who they're appointed by. It relies on the fact that they are controlled, they're managed, they're organised, that they can be subject to judicial committees and that they can be punished. And so the witnesses, in having this high control, have been hung by their own petard. The fact that they can disfellowship people has worked against them because it means that there is sufficient control to establish a duty there. So then he goes on to say, right, well, the second part of the test is this. Is there a connection between the relationship that we've just established does exist for those four reasons and the sexual abuse that happened? Okay, there might be a relationship between people, but it doesn't necessarily mean that anything bad that happens is as a result of that relationship. If my 17-year-old daughter walks 3 streets away and gets hit by a bus, despite the fact that I'm her mother and I'm her parent and legally liable for her, I'm not responsible for the bus hitting her. But if my 3-year-old son wanders down the street 3 streets away because I'm drunk on the floor and I've left the door open and he gets knocked down by a bus, then that harm could be said to be as a result of my relationship and my actions. So the second part of the test is there a connection between the relationship and the sexual abuse? And he does say that mere opportunity is not enough. Just the fact that somebody rocks up to Kingdom Hall and has an opportunity to do bad things, that's not sufficient to link the relationship and the bad things. However, he relies on another case, Maga versus Archbishop of Birmingham, 2010. And what he says in this situation is, where an individual uses a religious position of responsibility as a means to gain access to children, and at the time of such abuse he's not performing his specific religious role, then they can still establish vicarious liability. So if you're using your position in a religion, but the abuse doesn't happen when you are acting in that position, you can still establish liability. You don't have to be abusing them on field service or at Kingdom Hall or in the vestry or in the church to establish that link. If your position allows you access to children and gives you trust, then liability can be established. Maga goes on to say the priestly status and authority meant that no one would question his being alone with the claimant, and of course this applies to the Jehovah's Witnesses as well, doesn't it? They also say that there's a connection between the relationship and the abuse, specifically because the elders assumed responsibility. It says the elders knew that Peter Stewart was visiting the claimant's mother on a regular basis because the claimant's father, who had left the mother but was obviously still involved in some way, complained to the elders about that fact in 1992. So in 1990 they'd had a judicial committee with him and given him a private reproof. In 1992 the victim's father complained to the elders that Peter Stewart was visiting his daughter. And also it says they said it will have been obvious that Peter Stewart was driving the claimant's mother and her children to and from field service meetings. It says the mother relied on the fact that he was a ministerial servant as a way of trusting him. It said his involvement in her family was a direct result of Peter Stewart's known and established position as a ministerial servant. In fact, in her words, she'd said she was initially wary of Peter Stewart but came round to trusting him, in that he must be all right if he's allowed to come to East Leek, which must have been her congregation. They further rely on the words of the Watchtower Society from a confidential elders letter written in July 1998, which in part states, those who are appointed to privileges of service, such as elders and ministerial servants, are put in a position of trust. One who is extended privileges in the congregation is judged by others as being worthy of trust. So it said the elders knew about him being an abuser in 1990. They knew about him visiting this family with 2 daughters and a single mother in 1992, and they knew that people would implicitly trust him as a ministerial servant because of the elders' letter in 1998. So the judge says, in such circumstances, in my judgment, it is fair and just to hold the defendants to be vicariously liable for his acts. So because of all those reasons, he said, yes, you can be vicariously liable. So then he goes on in the final part of the judgment to discuss the claim. So he says, in relation to the claim, there are 3 issues to be considered. Did the elders owe a duty of care to the claimant? If they did they breach the duty of care? And if they did breach that duty of care, were they vicariously liable for the breach? So they rely on a case in Caparo Industries versus Dickman in 1990, where they say that it's to establish that it was foreseeable that harm would come. It's fair and just and reasonable that the law should impose a duty if harm is foreseeable. Okay, so if somebody turns up to the congregation, you don't know anything about them and you don't know they're an abuser, then it's not foreseeable that they would abuse someone, is it? So they're saying, was there a relationship of sufficient proximity between the elders and her, and would it be fair to and just and reasonable to impose a duty of care because it was foreseeable? So they say, yes, it was foreseeable. Foreseeability of harm was there because they already knew that he had abused other children. And they look at whether there's a sufficient relationship between them to say that they were liable for telling her, having known that there was a risk. Were they liable to tell her, right? So if I, for instance, I don't know that my neighbour is a really bad driver, do I have to go around and tell all my other neighbours to watch out when he's on the road? There's not really a sufficient relationship between me and generally other people that I could be taken to court if I don't warn them. Could the Watchtower be taken to court for their lack of warning? Well, interestingly, again, they rely on the Watchtower's own words to hang them, because Alan Orton had said in court that the body of elders has a responsibility to look after the congregation. In his words, he said, if there is anything unclean, the elders must remove it. So they said, well, bingo, you're assuming that relationship. You are actually saying we are responsible for getting rid of unclean things from the congregation. So they rely on the Watchtower's own words to say, yes, we have assumed a duty. Yes, they did breach that duty because, having known about it, they didn't tell anyone, and therefore they can be held liable for their actions. So in the summing up, the judge says, despite whatever may have been the good intention of the elders, I am satisfied that the congregation as a whole were either not warned at all or not adequately warned about Peter Stewart's sex abuse. I find that there was a breach of the duty properly assumed by the elders. So the elders said, yes, we are liable to keep the congregation clean. Oops, bet they never said that now. And therefore they did breach that duty. And therefore the Watchtower is liable for the actions of the abuser and the elders who failed to warn them. And of course they were fined £275,000 in damages and £455,000 in costs, which is a grand total of £730,000. Now, we know the Watchtower is going to appeal this case because knocking on £1 million is a huge amount of money for them to pay out, and we do know that the same law firm has other cases lined up behind this case should it prove successful. So what I'm hoping is that the appeal doesn't reverse the judgment but just varies maybe the costs or something like that. And all respect to this incredibly brave woman who suffered the most horrific trauma, and in the judgment it talks about how he kept her quiet as a small child, a 3-4-year-old. He told her that she was committing fornication and that God would destroy her at Armageddon, and that's what stopped her from telling anyone for years and years and years until she'd grown up and found out that he was coming out of prison. So I extend my love and respect and concern to the lady involved and her mother, and I hope that the appeal will go in the right direction as well. Thank you very much for listening.